Okay, the next keynote will be given by Dr. Thomas Gniadek from Norel LLP. The title of the keynote is Technical Standards in the Electronic Industry. Do you no longer own your inventions? So it will be an interesting talk. Career of Dr. Thomas Gniadek is as follows. He finished his legal studies at the University of Constance, the Cardiff Law School UK, and the University of Heidelberg. First state exam, having been a PhD candidate of Professor Dr. Thomas Dreyer, MCJ, Karlsruhe Institute of Technology, he received a PhD with summa cum laude from the University of Freiburg, admitted to the Munich Bar Chamber of Lawyers, experience as an attorney at law and patent litigator with an international law firm and with a renowned IP boutique law firm. With Neuer since 2015, he's focusing on patent law, national and international patent infringement proceedings, validity proceedings, licensing, technology transfer, R&D agreements, employee invention law in Neuer's Munich office. He's also a lecturer of patent law at the Technical University of Dresden. Okay, so please welcome Mr. Thomas Gniadek. Please.
Thank you. Hello, everybody. Thank you for having me at your conference. I'm not an engineer, I'm a lawyer, and that's why I will speak about legal issues today. I hope you enjoy it. My topic is technical standards in the electronic industry. More specific, I will talk about patents relating to technical standards. And the provocative question of this talk is, do you no longer own your invention? So if you form a standard setting organization and you create a standard, and in this regard you also come across some new innovations and apply for patents, the question is, do you own these patents or not? Of course you own these patents. Nobody wants to take your patent. So the better question would be, can you use your patent as you like in the context of technical standards, or do you have to observe certain restrictions or requirements the law imposes on you as a patent holder? What you must see in the context of technical standards is that there is a conflict between patent law and antitrust law. Usually, in patent law or in patent litigation, it's like the following. If you own a patent and this patent is valid and infringed, you have a statutory remedy against your infringer that is an injunction, meaning you can prevent the infringer from entering the market and you can prevent him from distributing this infringing product anymore. However, this statutory remedy is in conflict with your requirements following from antitrust law, meaning that a patentee shall not abuse its market dominant position. So why do you have a market dominant position in accordance with antitrust law if you are a patentee? That is, first of all, this follows from the patent itself. German courts have established that each patent establishes its own market, meaning the holder of that patent dominates that market because he can prevent any other competitor from entering that market, because he can say, you are not allowed to use my technical invention with your product. And on the other hand, if you participate in a standard setting organization and this organization creates a standard, many patents are relevant for that standard, meaning the standard setting organization agrees on specific features for that standard you have to comply with if you want to distribute a product standard compliant. But also in that process of creating the standard, patents are applied for and included in this standard. And then, yeah, it is obvious that if you use a product which is compliant with that standard, you also infringe that patent. So, as a holder of such a standard essential patent, you have a dominant position, and you can restrict other companies from using that standard and that patent if you are a holder of that patent. And the court said this might be difficult with respect to antitrust law, so they imposed certain restrictions on you. First of all, I would like to explain a little bit the process of standardization, because this is important to understand the whole mechanism. Standardization, as you all know, means that big industry players and research organizations join together because they want to move forward in a certain technical field, for example, audio compression or any other technical field. And that's why they set up a standard setting organization. This standard setting organization has the objective to create a certain standard and to to develop certain devices or to develop a standard, and if you comply with that standard, your standard compatible devices are compatible and work together. And so the standard setting organization, they agree on common specifications and common procedures and on a set of essential features for that standard. And if you comply with these features, your device works and is compatible. The advantage of such standardization is that the devices are interoperable, and the costs for research and development are tremendously reduced. And you avoid to lose a lot of money if you invest in a technology which is different from the standard but is not successful on the market. What is now the issue of standardization with antitrust law? In such a standard setting organization, industry players collaborate and agree on technical features. But this might exclude other competitors from entering the market, because if they do not comply with the standard, their products are not compatible and might not be successful on the market. And if they comply with the standard, they might infringe the patents which were created in the process of coming to that standard. This means that the participants in that standard setting organization have the power to control the market and exclude other competitors. And this is exactly what antitrust law wants to prevent. Of course, all standard setting organizations know that problem with patents, and that's why they have own patent policies or IPR policies, meaning if the participants in that standard development process realize that a certain feature which is discussed would be or requires a use of a patent they are currently applying for, they have to disclose this to the other participants of that standard setting process prior to approval of the standard. And additionally, anyone who realizes that its patent might be essential to that standard has to submit a so-called friend declaration to the standard setting organization, meaning that he's willing to license the standard essential patent under fair, reasonable, and non-discriminatory conditions, so-called friend conditions. And this friend declaration, how it is called, is essential for the whole process of litigation. Also, it follows from antitrust law that you have to submit such a friend declaration, meaning that any competitor has a claim for compulsory license under fair, reasonable, and non-discriminatory conditions. The litigation scenario is now as follows. For the patentee in such a scenario, it's very easy. If you own a standard essential patent, it's easy to show infringement of that patent, because any product who claims to be standard compliant uses your patent. So this requirement for having successful litigation is easily fulfilled. And then under German patent law, the injunction is a statutory remedy, meaning the courts have no discretion in granting that remedy. That means if your patent is valid and if you can show it is infringed, then the injunction will be granted. Meaning from there on, you can prevent your competitor from distributing his product anymore. So as a patentee, you have a very strong position if you own such a standard essential patent. For the possible infringer, the defendant, it's not that easy. The only thing he has is his claim for a friend license. So he can approach the patentee and asking for a license under fair conditions. But the question is, what can he do if litigation was started? What is the consequence of his claim for a friend license if the patentee already sued him for patent infringement? Meaning, can he take this claim for friend license and turn it towards the claim for an injunction and use it as a defense in patent infringement proceedings? In Germany, we had a lot of litigation relating to standard essential patents. All relating to mobile devices and mobile technology. The leading case in this regard is the Orangebook standard case. And this case established that the defendant may invoke his claim for a friend license as a defense in patent infringement proceedings. However, he has to fulfill two very strict requirements. Meaning, if the defendant is faced with a patent infringement action, he must make an unconditional offer to the plaintiff to take such a license under friend conditions, and he must immediately stop these infringement proceedings. He must not stop the infringement proceedings, but he must fulfill the obligations under this friend license, which he offers to plaintiff in advance. That means he has to render accounts for the past about the distribution of his device. He has to deposit that license fee on an escrow account, and so on. This means in parallel to the litigation which continues, he already needs to fulfill the requirements of the license he offers. And at this point in time, it is not yet established that there is a patent infringement. In this regard, unconditional means that the defendant must make this offer without placing a condition that the patent is infringed. So actually he has to totally surrender and accept, accept the situation that he is infringing the patent and has to take a license. There's further findings according to German law, which even so the situation became even worse for defendant, meaning that he can only rely on that friend defense if he withdraws its nullity action during the proceedings. And it was established that an unconditional offer means that defendant must drop all objections relating to his obligation to pay royalties in principle, meaning he can still contest the amount of the royalties he's owing, but he cannot contest the principle that he's owing royalties. Also, on the European level, the European Commission dealt with the issue of patent litigation with respect to antitrust law. In this regard, the European Commission developed the concept of a willing licensee, meaning if the defendant can show that he's a willing licensee, he is entitled to that friend defense and may turn that friend defense against the claim for an injunction. Willing licensee, but the requirements which were established by the European Commission and the requirements which were established by the German courts are different. So the German approach is much more stricter than the approach of the European Commission. For example, the German courts require that a defendant who wants to invoke the friend defense does not challenge the validity of the patent anymore. This is not requested by the European Commission. So the requirements of the European Commission are much more in favor of defendant. However, if you see the current situation until this summer, you must conclude that for a patentee, it is very easy to rely on a standard essential patent in patent litigation. He can sue the possible infringer right away without observing any requirements prior to that litigation, and the patentee can directly request the granting of an injunction, whereas the defendant, on the other hand, must show that he is entitled to invoke that friend defense for avoiding that injunction. And he must, for example, in Germany, fulfill very strict requirements for relying on that friend defense. This was the situation until this summer, but now things are totally different. The district court Düsseldorf asked itself whether that can be right, or whether the current rulings of the German courts conflicts with European antitrust law. And that's why the Düsseldorf District Court asked the CJEU for a preliminary ruling on the question of European antitrust law with respect to patent law. And the CJEU came to the following finding. He said, the patentee might might abuse its market dominant position if prior to the filing of a patent litigation he does not follow a specific procedure in order to negotiate a friend license with the possible infringer. Sorry. And if the patentee does not meet these requirements of that procedure, this might constitute an abuse of a dominant market position, meaning that he can no longer request the injunction he requested. Now, what is the procedure the CJEU requests? The European Court turned the scenario completely. It's no longer the defendant who has to fulfill certain requirements. Now it's the patentee who has to fulfill certain requirements, meaning even prior to litigation, so before he can file a patent infringement action, the patent holder must alert the possible infringer of the alleged patent infringement and must designate the patent he's relying on and the reason why he thinks this is an infringement. The infringer now can decide whether he wants to show a willingness to license this patent, and if he does so, the patentee must make a written offer, a written license offer in accordance with the friend declaration he submitted, and in this regard he already has to state the amount of royalties and his calculation. And then the infringer has a further chance to respond to that offer and can decide whether to reject that offer or not. If he rejects the offer, he must make an own offer and comply with that offer in advance again. If these negotiations are unsuccessful, the parties can turn to a court who determines the amount of a reasonable royalty. The most important thing about this is that when the patentee does not comply with that procedure, he is not able to request an injunction. So this totally changes the scenario to the situation before. What we would expect, because an injunction is no longer available that easily, we would expect that there will be fewer infringers of standard essential patents who accept a license before patent litigation is initiated. And we expect that there will be an increase of court proceedings regarding the determination of a friend royalty. And it is less attractive for a patentee to start litigation right away. One can conclude that for somebody holding a standard essential patent, it is less attractive to have such a patent, and he's now forced to enter into license negotiations before starting patent litigation. Sorry, I have to stop that here. I'm not. I put down some chances and risks of that new case law I may upload that on your website. Sorry, I'm not able to do that today. Thank you.
Thanks for the speech. It's definitely, for me at least, it's a kind of a arena that we started to play lately regarding patents and filing these and everything. So it's kind of a really, it's not all about technology. There is much more about law and different requirements. So I think if it's an interesting topic. So if anyone has any questions, please. Yeah. Do we have a microphone?
So I think it was, I work for an SSO in the U.S. Of course, IEEE is an SSO, and they made a change recently that has to do with, how do you put it, like the minimal implementation, you know, so whether a patent applies to the chip or the finished product and how you value that. Do you know what I'm talking about? So is that, how does that play out here in Europe? Is there, I assume there's case law on that?
I think that's a different topic to what I'm talking about here.
Yeah.
The topic of that presentation is whether you can request an injunction and whether you can enforce that injunction if you rely on a standard essential patent or not. Or put it more broadly, whether it is still attractive to participate in a standard setting or not,
Okay.
if you apply for a patent. And one can say that in the past it was very attractive to be part of a standard setting organization, because not only did you create a standard, you also acquired lots of patents, and it was very easy to prove infringement with respect to these patents, because of course any product which is standard compliant also uses your patent. And in Germany there was, or all over Europe, there were no real boundaries for enforcing a standard essential patent. To the contrary, it was on the defendant to show that he fulfills certain requirements and can rely on the so-called friend defense.
Okay.
Now it's different, meaning that if you have a standard essential patent, you have to approach defendant before the patent litigation and ask him whether he wants to take a license.
Okay. All right. Thank you.
Thank you.
Tom, very interesting talk. My company in the UK, Regis, is going through a patent filing at the moment, so I'm quite interested in this topic. But on that, could you probably comment about international boundaries and where patents are recognised, whether you register them in one country like the EU and they're not recognised in the US, or you have to do multiple filings on that to protect your, particularly if it's a product or an invention you've got that could be internationally applied? Are you able to comment on that at all from the EU perspective?
So I understand that you want to achieve a global protection of your patent?
Correct. For instance, airspace management is what we're working in. So we have a solution for that. So I won't go into detail, of course, but we are currently going through the filing for our system or our solution, and we started that in the UK. But I was using that more as a general example of particularly in the consumer electronics industry, which has a global market. And obviously people would want to protect their invention, if you like, internationally, or do as best they can.
Normally, if you file for patent protection, you file for or you apply for a European patent, and for example a Japanese patent and a US patent. And it is not necessary to have more patents all over the world. This is only necessary in the pharmaceutical industry. In the electronics industry, normally the people have patents in the US, in Japan, and in Europe. And you know that in Europe, it's not a unitary patent. It's a bundle of national patents. And usually you validate that patent in the UK, in Germany, maybe France, maybe Italy. And these are and in Netherlands probably. And these are the major markets. And to gain leverage over your competitor, it's absolutely sufficient to initiate patent litigation in one of these countries for protecting your global market. Was this your question, or?
Yes, it does.
Yeah.
Oh, an indication of sometime the time frame that this could take, like 12 months or 6 months? Or?
Until you have your patent granted?
From the filing process to when, like, obviously the process can't go on forever. It has to have a finite time when you start the process to when it needs to be completed to have the patent authorized or in place.
2 years to 5 years, something like that.
Okay.
Mm-hmm.
Thank you.
Hello. Under Huawei, we had some changes, as you refer, that impact on company decisions on going for a standard body or not. What I would like to ask is if recently there is already some statistical data, some data concerning what's happening, if really companies are really coming out more of the standardization bodies, or that is not really the decision.
This decision was rendered, I think, about 2 months ago, mid of July. So this is very fresh. So you cannot estimate which consequences it will have. What you can say, a standard essential patent is not attractive than it was before. However, it's still very, very attractive. To have a patent is very attractive. So, and if you weigh the pros and cons for participating with a standard setting organization, I would say do it, participate. It's better for you than not. Because, of course, the alternative would be you stay out and you develop your own product which is not standard compliant, and you might also get certain patents out of that. But what is the value of such a patent? Nobody would use it because all the other competitors or all the other players in the market, they would produce standard compliant products. So you are the only one having your product which is not interoperable, and you have your patent, but nobody uses your patent because they comply with the standard which has different patents. So the advice is it's less attractive than before, but it's still very attractive. And however, it's not that easy to enforce such a patent in patent litigation than it was before, and yeah, that's why you need advice before you do that.
Any other questions? No? Okay. Okay, so thank you, Mr. Gniadek.
This is a small present for you from the